Everything's right here. Yep.
This first and then this.
Okay. Sounds good. Yeah, right? Yeah, yeah, yeah.
What? A deer? Where are you? Oh. But they're probably going to school. They're probably going to school.
Juvenile. That's juvenile. She's hitting sidebar then. Oh, yeah, totally. Okay, you good? So sidebar only picks up the judge and the front of bench. I'll talk.
Can you hear me at the main jail? Please raise your hand if you can hear me. Okay, thank you. Good morning, my name is Judge Cal Evans. This is your first appearance. You can put your head down, sir. Thank you very much. I'll be letting you know what charges have been presented, what, if any, conditions of bond may be imposed. And keep in mind, everything you say is being recorded. For those who don't already have private counsel, I am appointing the Office of the Public Defender provisionally for the purposes of this hearing only to represent you. If you wish to retain their services, please fill out an application. And I've been asked to address two cases out of order, and that's Krishna Murti Singh.
Mr. Singh is still present, Judge Amain?
And
Good morning, Your Honor.
good morning.
It's Fred Braun for Krishnamurti Singh.
It's your turn.
All right.
Hello,
Mr. Singh, good morning, sir. Your attorney is present this morning.
Thank you, sir.
And 3 counts have been presented, sir. Possession or promoting depiction of child sex conduct, person in-state transmitting child pornography and compile or entering computer child pornography or depiction of sexual activity by a minor. Sir, I do find probable cause to detain you on all three charges, and as to conditions of release.
Yes, Your Honor. We're asking for a $10,000 bond per count to be imposed. We're also asking that there's no access to devices with internet access. That there's no contact with minors. That he surrender his passport. And if he were to post bond, we ask for a pretrial release with GPS monitor.
Pardon me?
And for the last one is if bond is posted, that we would ask for pretrial release and GPS monitor.
Okay.
And for the record, this is Joshua Vince for the state.
Thank you, Mr. Vincent. And any argument as to conditions of release?
Well, as to the conditions, Your Honor, I think the GPS is a little bit over, but I don't have a problem with it. And as to the rest of the conditions, they're fine. The amount of the bond is a little prohibitive. It would be $30,000. Initially, the bond was listed as $1,000 on the one, and two others will hold for magistrate. If we could keep that at $1,000 and the other two at $10,000, I think we can still get it done in terms of the money, and he can get the GPS upon release. That's fine. He only goes to work and goes home. He doesn't go anywhere else. So.
All right. I will set bond at $15,000 on count 1, $1,000 on count 2, and $15,000 on count 3. In addition, sir, should you be released, you'll be on GPS. You're on pretrial with a GPS monitor, and you will not have be able to have any access to computers or any device that can access the internet. No unsupervised contact with minors. State, I do note that he does have minor children. So no unsupervised contact with minors. No contact with the alleged victim or the other party that you were contacting, you were alleged to have contacted on Facebook. And I will impose the condition of surrendering your passport as well.
Your Honor, I did hear the court say GPS monitor. Is the defendant permitted to work?
Yes. But again, no unsupervised contact with minors while doing so. All right, sir.
Judge.
And a hearing will be set before your trial judge as soon as possible. Good luck, sir.
I'll speak to you soon, Mr. Singh.
Thank you. And we also have Gary Levy.
Mr. Levy is here, present, Judge, and there's your private attorney. Good morning, Judge.
Good morning, Your Honor. Bob himself and Mr. Levy.
Good morning. Mr. Levy, 2 counts have been presented, sir. Burglary of an unoccupied dwelling and petty theft. I do find probable cause to detain you, sir. That's the conditions of release.
Your Honor, we're asking for a $5,000 bond, as well as pretrial release with a GPS monitor.
Judge, we have no objection to the $5,000 bond. A GPS monitor, I really don't think is necessary. He's not a flight risk. His 2 sisters are attorneys. His father's an eye doctor. I'm in touch with them. His strong family ties. He sees a mental health therapist regularly, is on medication, so I don't think he's a flight risk at all, Judge.
His family, they're local?
No, they're not local. Well, his dad's in Tampa. His 2 sisters are up in Boston.
Okay.
And he's currently on probation for an unrelated charge that this predated that. He's in constant contact with probation, has not violated, so he's clearly not a risk of flight.
And he's on probation in Broward County?
In Broward County, correct.
Okay.
And lives here too.
All right, sir, having found probable cause to detain you, I will set bond on count 1 at $5,000, count 2 at $100. I'll place you on pretrial. I will not impose a GPS monitor, and no contact with the victim, no return to the premises, sir.
Excellent, Your Honor.
For the record, that is standard pretrial upon posting his bond, is that correct?
That is correct.
Thank you, Your Honor.
You're very welcome. Have a
Thank
good
you,
day.
Your Honor.
Good luck, sir.
Thank you.
All right. Do we have any other cases that need to be addressed out of turn? Having heard none, we have Jordan Gibson.
Good morning, Your Honor.
Good morning, ma'am. Ma'am, you have an out-of-state hold that has a no bond. It's been set no bond. I do find probable cause to detain you, ma'am, and I wish you the best of luck.
Yes, thank you.
Take care.
You too.
Kimberly Rubin.
She's here present, Judge Amain.
Good morning, ma'am.
Good morning.
Ma'am, you likewise have an out-of-state hold with and it's a no bond hold. I do find probable cause to detain you, and I wish you the best of luck. Michael LeBlanc.
Judge, one moment. The only request we would have with Ms. Rubin, and I apologize, just found this out, would you sign a phone order allowing her to access her phone contact so she could let her family know that she's here in custody?
I will allow her to view her phone for the purpose of obtaining contact information under the supervision of law enforcement.
Thank you, Judge.
You're welcome. And do we have Mr. LeBlanc? Okay. Thank you. Sir, good morning. Sir, you also have an out-of-state hold. It is also set at no bond, sir.
And we would just be requesting, Judge, a phone order so we can access his phone contacts under the supervision of law enforcement so we can contact his family, let them know he's here.
Okay, I'll sign a similar order to the last case. And, sir, I have found probable cause to detain you, sir. Good luck. Yes, sir. And Sinceria Cook.
Ms. Cook, come on up, please.
Good morning, ma'am.
Good morning.
Ma'am, you have a violation of probation warrant, and I do find probable cause to detain you. And bond has been set at $1,000 on that warrant. Good luck, ma'am. You have a hearing that will be set before your division judge. It has not yet been set. Nicole Cooper.
Yes.
Good morning, Judge Evans. She's a no, Brown.
Good morning.
Good morning.
Good morning, ma'am. Ma'am, you have one count of trespassing, that's a municipal ordinance, and one warrant for failing to appear on another city ordinance case as well.
Judge, can you resolve?
No, I didn't have. I went to jail for the warrant already. It was for the trespassing. I just got out of jail not too long ago for that.
You resolved it at that time, ma'am?
Yeah, I did.
Do we have a disposition on that case?
They gave me time. They gave me time to serve for it. I did it overnight.
When was that, ma'am?
I think last month. I'm not sure on the date, but it was last month sometime.
All right, if the parties care to look up, I know neither party has a vested interest, given that this is a city ordinance case.
Your Honor, I'm showing that there was a December 20th, 2016 case, there was a trespass that was pled out for time served. I'm just gonna double check that that's the most
What was the
recent one.
case number on that?
The case number on that, Your Honor, is 16-011-542 MM10A.
I'm sorry, 4614?
Yes.
That's not the one she's talking about.
Okay, no, that's a different case, ma'am.
No, this different one.
So, okay, what is the warrant? What is, I don't know what the warrant is for. I
This
don't,
is a notice, she got a notice, this is a notice to come up here.
That's sleeping in public, sleeping on a public street, sidewalk, or public place.
oh, that's what, the laundering or whatever? The launder. I just know I have a court date on the 22nd, and that's the only court date. I didn't know about any other court dates. Cause I have like the tickets and stuff to pay, but I just go to the court, on the court date when, that's why I don't know about.
Ma'am, this
So I
warrant,
don't know about no warrant or anything.
it was
I don't know.
issued on December 11th, 2017.
Yeah, they told, that's what they said they rescheduled it for the 22nd. That's why I'm supposed to go to court on the 22nd. I had a court date on December 11th, and I called to make sure what time in the room, and they told me that they rescheduled it on the 22nd.
Mr.
So
Vincent,
I'm supposed to go January 22nd. That's what the lady told me.
just
I
one
called.
moment, ma'am, I can't confirm anything if you're speaking. Just one moment, please.
Your Honor, she has a January 22nd, 2018 arraignment in case number 17-005-138 MO40A, in charges carrying open uncovered beverage in public.
What about the case 17004614, MO?
Your Honor, there was an arraignment on December 11th, 2017, and there was a capias served on, the capias was served on that case yesterday as well.
Okay. Ma'am, you are correct that you do have a case that is set in January.
Yeah.
Not this case, ma'am. Not either of these cases. So these are two separate cases that were not part of that. This case has an outstanding warrant, well, count two has an outstanding warrant from December 11th for a failing to appear. And then there's a new case, and that is the trespass after warning. And I do find probable cause to detain you, ma'am.
Yeah.
Do you have an attorney?
No.
Did you wish to hire an attorney or see if you qualify for a court-appointed attorney?
I guess the public defender, I don't.
Well, the public defender does not, they wouldn't represent you, but there are other attorneys that are contracted with the cities to represent.
Okay, well, I don't have no attorney or anything.
Did you wish to fill out an application for one of those attorneys?
Yeah, that's fine.
Judge, when I talked to her, she indicated she wanted to resolve if possible.
Yeah, I wanted to resolve it. I didn't know about the warrant because the only thing I know was about the 22nd. Nobody said anything. I called December 11th because I knew I had a court date then, and they told me that they scheduled it for the 22nd.
If anyone wants to provide me with a copy of the probable cause affidavit, as all parties are aware, the court would not have any probable cause affidavit on case number 17004614 MO40A. Ma'am, is it your intention to resolve both of these cases today?
Yeah, I would like to resolve it, yes.
Okay, just one
I
moment, ma'am.
didn't even.
Ma'am,
Okay.
ma'am, just one moment.
Okay.
I can't do anything until I have paperwork. All I have is the warrant for that case, so I cannot. She's got it, but I don't have it. So I can't find a factual basis.
May I approach, Your Honor?
Yes. All right, ma'am. If you'd like to resolve both cases, I'd give you an adjudication, time served, court costs on both.
Okay. Can I ask you a question, sir?
Yes, ma'am.
Okay, so can I get this like cleared up so I don't have like no more warrants or anything? Like, and my court date is for the 22nd, right? That's my next court date.
On a different case that has nothing to do with anything
Yeah,
that we're addressing today.
No, I know. I just wanted to make sure because I called the clerk
Mr.
of
Vincent,
courts
you
and they
said it
told
was the
me-
22nd?
Yes, Your Honor.
The 22nd, ma'am.
Okay, thank you. I just wanted to make sure.
Okay. Now, can we please place Ms. Cooper under oath on this case?
Ma'am, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth and nothing but the truth?
Yes, ma'am.
Please state your name for the record.
Nicole Cooper.
Thank you.
All right. Ma'am,
Yes.
are you currently, first, you already indicated you don't have an attorney.
Yes.
You understand you have the right to counsel, the right to have an attorney.
Yes.
An attorney could look into your case, demand discovery, get copies of police reports, witness statements, let you know what your defenses are, the consequences, file legally appropriate motions, take the case to trial. You understand that?
Yes.
Is it your intention to waive that right on both of these cases so you can resolve these cases?
Yes.
Okay. And are you currently under the influence of any medication, drugs, or alcohol that would affect the way you think?
No.
In the past year, have you been treated for a mental illness?
No.
You understand that you've been charged with sleeping on a public street, sidewalk, or
Yes.
other place, and the city-owned property, as well as trespass after warning.
Yes.
And the maximum penalty on each is 60 days in jail or 6 months probation. The maximum penalty, not the offer. You understand that?
No. Yes, I understand.
And the offer is an
Judge,
adjudication.
Judge, is this Donna McCarthy?
No, it is not.
Okay, thank you, Judge.
You're welcome.
Sorry, I didn't mean to interrupt you.
No problem. And let's see. You understand if I take your plea, ma'am, you're going to be your pleas on 2 cases. You're going to be waiving certain constitutional rights.
Yes.
Those rights include your right to maintain your pleas actually, of not guilty, your right to present defenses, file motions and pleadings, your right to remain silent, have the city prove your cases beyond a reasonable doubt, your right to confront and cross-examine every witness against you, call witnesses on your own behalf, and appeal any prior rulings of this court. Do you understand those rights, ma'am?
Yes.
Do you wish to waive those rights so that you can take these pleas?
Yes.
And you understand if you're not a U.S. citizen, taking these pleas will subject you to deportation proceedings.
Yes.
Under the Jimmy Rice Act, if these were sexually violent or sexually motivated offenses, or in the past, if you've been convicted of such offenses, taking these pleas will subject you to involuntary civil commitment.
No.
Do you understand that?
Yes.
Okay. And knowing and understanding everything we've discussed, ma'am, how do you wish to plead? No contest? Or
Yes.
Okay, no contest. And, ma'am, based on the court's review of the court documents, including the probable cause affidavits, I will find that there is sufficient basis to take your pleas. Is there anything that you would like to say before I pronounce sentence in your cases?
No.
Okay, you don't have to say anything. It's your opportunity to say something if you wish to. But I will accept your no contest pleas, and I'll find that you freely, voluntarily, and intelligently enter into these pleas, that you understand the nature of the charges against you and the consequences of taking these pleas. And I will honor the agreements, ma'am, and I will adjudicate you on each offense, give you credit for the time you served, and assess court costs. And Madam Clerk, the court costs in each case? $38 on count 1, $78 on count 2, ma'am. I'll give you 6 months to pay the court costs, and you have 30 days to appeal the court sentences. Good luck, ma'am.
Thank you.
You're very welcome. Debbie Maldonado, Retriage.
Yes.
Judge, can we take Diaz when you have time? The interpreter's here.
Oh, I just see it.
Paul Ryan.
Well, we'll take that one next. Good morning, ma'am.
Good morning.
Ma'am, you have 6 warrants for your arrest, and I do find probable cause to detain you. And each bond has previously been set at $100.
Judge, she wished to resolve, if possible, and she's planning on either doing bark or some other kind of program.
Based on the number of offenses and the time in between each failure to appear and the failure to avail herself to the court is not inclined to resolve at this juncture. Ma'am, you're gonna have a hearing before you're assigned judge. Okay?
Okay, do you know when?
It hasn't been said as of yet because you've just been taken into custody.
Okay,
Okay? Good luck, ma'am.
okay.
And let's see, the case that we need to address now is,
Yes, page 12.
okay,
Paul Ryan.
pages, just packets. Is that Ramon Diaz Hernandez?
Yes, sir.
Okay.
He's a Conti inmate at Paul Ryan. Yeah, there you go.
Wait,
They must fix, I'm at Paul Ryan, they must fix my camera, so Paul Ryan.
all right, okay. Good morning. And can we please swear in the interpreter?
I do. Maria Salazar, certified court interpreter. You're welcome.
All right, State, do you have any further paperwork on this case?
Sí, la fiscalía tiene más documentos sobre su caso.
I merely have the warrant.
No tengo una orden de arresto enfrente mío.
You don't have the facts, Your Honor?
No.
No tiene los hechos.
One moment, Your Honor.
Un momento.
And can you please make a copy for defense? So was this filed by information?
Yes, Your Honor. It was filed by information. There's 5 counts.
El documento acusatorio presenta que hay 5 cargos.
And count 5 on the information reads?
Count 5 on the information reads
El
battery, Your
cargo
Honor.
5 es agresión.
Counts 1 and 2 are sexual battery, great force not used.
Y del 1 al 3, agresión sexual sin usar fuerza física.
This is an add charge, it looks like, Judge, because
Me
on this,
parece que el 5º es un cargo añadido.
Bond has previously been set on the other counts.
50,000 for the
50,000
previous sexual battery.
En los cargos de agresión sexual.
Is this being presented as a change of charge or just simply an add charge?
Están
Says
viendo a ver
count
si
5,
cambian
Judge, so I
el
don't
cargo.
know.
El cargo en el 5º
This
el
looks like an
cargo.
ad charge, Your Honor.
Okay, it looks like a change of charge on the
Cambio
CAPIS
de
itself.
También en la orden de arresto.
Count 1 on the booking sheet indicates
En el primer
sexual
cargo,
battery,
agresión
victim
sexual es
over the age of 12,
con la víctima mayor de 12 años.
and on the warrant,
Y en la
What was
orden de
signed?
arresto,
let's see, yesterday,
que fue firmada ayer,
it indicates sexual battery, great force not used.
indica agresión sexual sin usar fuerza mayor. En el 5º cargo se mencionan los otros 4 cargos primero
And
y se
Judge,
añadió uno
Which
más.
is the 5th count? Because there is already a
Están
count
viendo
of battery.
cuál es el 5º cargo.
Okay,
Judge,
Agresión sexual sin
I see
usar
only
fuerza mayor.
facts for 1, I don't see a separate
Ahí
incident.
el
I'm asking that you
abogado
not find
suyo dice
probable
que hay
cause as to this.
hechos
If
del
he's-
caso
is
para
indeed
uno de los cargos.
Has still charged as the other one.
Mr. Vincent?
It's for 48 hours to perfect.
Sorry, interpreter, I didn't hear you.
We would ask for 48 hours to perfect.
Están pidiendo 48 horas para revisar esto.
Granted.
Se le ha otorgado.
Sir, we're gonna be back in 2 days.
Señor, vamos a ver esto en 2 días. Va a regresar en 2 días.
Good luck, sir.
Que tenga buena suerte.
Ok, gracias.
Thank you.
It should be before. Okay. We can send it to Judge Cohen. Yes, please. No, Monday. Tuesday.
Este es un cargo de violencia doméstica que estuvo también frente del juez Cohen. Y lo van a fijar en frente del juez Cohen.
Thank you, sir.
Gracias, señor.
Could you please make another announcement? Just in case?
Una persona. Is there anybody else that needs the Spanish interpreter? ¿Hay alguien que necesite la intérprete?
In any facility.
No one at
En
Maine.
cualquiera de las instituciones.
No one at Maine.
Okay.
Anyone at Paul Ryan, Conti, or North Broward? Okay, having heard nothing, have a wonderful day and a wonderful weekend as well.
Thank you. You too.
Donna McCarthy.
North Broad, Your Honor.
Judge, I believe Ms. McCarthy, Mr. McLawrence spoke to her, and he's on his way over there to the courtroom. He asked me to be on the lookout for her name and let you know that he's on his way to address that case.
Mr. McLawrence is actually in the courtroom right now.
Oh, he must have ran, Judge. It's a fast walker, Judge.
Good morning, Your Honor.
Good morning, Mr. McLawrence.
Judge, I spoke to Ms. McCarthy this morning. Her matter is a little interesting only in that the police officer, and I do have the probable cause affidavit for the court. May I approach?
Yes, please.
Your Honor, the officer charged her with trespassing when possibly or probably the more correct charge should have been panhandling. And you could derive that from the probable cause affidavit. Notwithstanding that, Judge, in speaking with Ms. McCarthy, she expressed to me a desire to resolve this matter so that she could get out of jail.
It looks like they presented trespass because of the no trespass affidavit that was on file, and they indicated the number was 34-1602-022009.
But in reading the probable cause affidavit, it says that she was panhandling.
That was a factual allegation as well. But the reason that it indicates she was trespassed is because they advised her and she refused to comply. That she was trespass warned and refused to comply. So it will be a trespass after warning. I can resolve it as presented.
Yes, Judge, she desires to resolve the matter, Judge.
Okay. Does she have priors? We don't have the city here.
Another city case from July of last, 2 years ago, Your Honor.
All right, I'll do withholding court costs. No return. Mr. McClellan, is that something she wishes to accept?
Yes, Your Honor.
Okay, can we please place Ms. McCarthy under oath?
Ma'am, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth and nothing but the truth?
Yes.
Please state your name for the record.
Please state your name for the record, ma'am.
I'm Dawn McCarthy.
Thank you.
All right, ma'am, you have one count of trespassing after warning, and it's been presented. Did you want to resolve that case this morning?
Yes.
Okay, and Mr. McLawrence is present in court this morning, okay?
Yes. Yes, Your Honor.
And let's see, are you currently under the influence of any medication, drugs, or alcohol that would affect the way you think?
No, sir.
In the past year, have you been treated for mental illness?
No, sir.
You understand you've been charged with trespassing after warning?
Yeah, I think, yes, I do, sir.
Okay, the maximum penalty is 364 days in the Broward County Jail. Not the offer, but that's the maximum penalty. You understand that?
Yes, I do, sir.
The offer is a withhold of adjudication and court costs and no return to that premises. You understand that?
Yes, sir.
Okay. That's 831 West Sunrise Boulevard, Fort Lauderdale, Florida, 33311. Did anyone promise you anything different, ma'am?
No.
Did anyone threaten, force, or coerce you to take this plea?
No, sir.
You understand if I take your plea, you're going to be waiving certain constitutional rights? If I take your plea, you're going to be waiving certain constitutional rights.
Okay, yes, sir.
Ma'am, those rights include your right to maintain your plea of not guilty and have a trial, your right to present defenses, file motions and pleadings, your right to remain silent, have the city prove your case beyond a reasonable doubt, your right to confront and cross-examine every witness against you, call witnesses on your own behalf, and appeal any prior rulings of this court. Do you understand those rights, ma'am?
Yes, sir.
And ma'am, do you wish to waive those rights so you can take this plea?
Yes.
Are you satisfied with your attorney?
Yes.
Have you had enough time to speak with him?
Yes, I did.
And you understand if you're not a U.S. citizen, taking this plea would subject you to deportation proceedings?
Yes.
Under the Jimmy Rice Act, if this were a sexually violent or sexually motivated offense, or if you previously had been convicted of such an offense, taking this plea would subject you to involuntary civil commitment. Do you understand that, ma'am? Okay.
Yes, sir.
Ma'am, knowing and understanding everything we've discussed, how do you wish to plead? No contest or guilty?
contest.
No contest? And is there stipulation as to the factual basis?
Yes, Judge.
Based on a stipulation and as well as the court's review of the court documents, including the probable cause affidavit, ma'am, I will find that there is sufficient basis to take your plea. Is there anything that you would like to say before I pronounce sentence on your case?
No, Your
Okay, I will accept your no contest plea, and I'll find that you freely, voluntarily, and intelligently entered into this plea with the advice of competent counsel with whom you're satisfied, that you understand the nature of the charges against you and the consequences of taking this plea. And I will honor the agreement, ma'am. I will I will withhold adjudication and assess court costs in the amount of $78 in order that you not return to 831 Sunrise Boulevard, Fort Lauderdale, Florida, 33311. So you cannot go back to that location, ma'am. You understand that?
Yes. Yep.
I'm gonna give you six months to pay the court costs and 30 days to appeal the court sentence. Good luck, ma'am.
Thank you.
You're very welcome. Mr. McLaurin, did you have anything else?
Yes, Judge, I have, there are three more persons, Judge. I think on the next page, page 5, I don't have the docket to tell you how many people down she is, but there's Sabrina Moore. She's also in North Broward, Judge.
She's the next one up.
Okay. Judge, could I approach, I have the charging document in case 176357 MO10A. I have the information, Judge. I don't have a probable cause affidavit. Strangely, there was not one on the clerk's website. But I do have the probable cause affidavit in 173625 MO10A.
Sorry, which one is missing, the 6357?
Yes, Judge.
Mr. Vincent, would you be able to assist?
Yes, Your Honor.
We don't have a paperwork. We put them up.
No, I know you don't have it. I didn't know if it showed up, if he was able to print it out.
We're looking for a PC in which case, Your Honor?
It's 176357 MO10A. I gave the judge the information. Right.
Actually, I only have one information. There's two separate cases.
Judge, that was what I was trying to inform the court. In 6357, I did not see a probable cause affidavit. The state hasn't seen a probable cause affidavit either. I do see the charging document, however.
I don't have the charging document or the. Let's see, I don't have the charging document.
I gave you the information for 6357, Judge.
Okay, so I have the PC for 6357.
You have the PC for 3625.
Oh, 3625. And the charging document for that case as well.
No, the charging document you have in your hand is for 6357, Judge.
So I'm missing the charging document on 3625 and the PC on 6357.
But Judge, notwithstanding that, I spoke with Ms. Moore this morning, Your Honor, and she desires to resolve her matter, Your Honor, but I'm not comfortable with requesting that from the court. I have some concerns about Ms. Moore's mental health status, Judge, and I'm going to request if the court would if the court would order a mental health screen evaluation, and that BSO provide any medication that it deems is necessary.
Mr. Vincent, you don't need to look any further.
Okay.
Thank you, sir. And I do see the visual presentation as well. The court does share the concerns, so I will order the screening. And any objections to transferring this to mental health court?
No, Judge.
Okay, ma'am, I do find probable cause to detain you on both counts, and I will transfer this case to, I'm transferring the case to Seminole Court. Yeah, you can, however, you do have an attorney here.
Okay. I don't want to, a screening inside the jail. I could take your prescription and go for R&R. Because my charge is not really that, it's just a misdemeanor warrant. It's not a serious charge. It's just a misdemeanor. So a screening to take prescription home, yeah, for a program, not inside the jailhouse. But to go back to outreach Bible, their program on the out, like input at Valley House of Hope.
Okay. I understand your desires, ma'am. The concerns that your attorney have and the court has as well. I'm going to send this to a courtroom that's more appropriate to deal with the issues at hand, okay?
Well, I can say, they said for me to go home today. Is that, can I say something?
Yeah, yes, ma'am.
For me to go home today, it'd be more appropriate than me going to mental health court. I have class, and I just rather for it to be. It's very appropriate for me to go home today, out of this jailhouse, not into a mental health court. It'd be more important.
Okay, you understand that the case won't go away because you cannot resolve it. And if you cannot resolve it right now, you couldn't plead the case out. Because right now I have concerns that you don't quite understand the charges against you and whether or not you're competent to proceed. I understand that you're asking for pretrial, but you're not directly responding to what I'm saying, which even furthers my concern.
What is your I can't see your name, sir. Evans?
Yes, ma'am.
This is not a mental health court?
No, ma'am.
I don't want to stay in the jail for not a serious charge. It's just a warrant. And I would like to go home today.
I understand, ma'am.
I have my children and my family. And I'm afraid of being in this jailhouse.
Judge, I'm not sure if there's a way that we could get her in front of Judge Wren as early as possible, possibly on Monday. I'm not sure if that's something that we could do from here or not.
If you can call.
I'll get in touch with Joanne, Judge Wren's JA, and see about the quickest date that we can get her in front of Judge Wren, Judge.
I'd rather to be home today and not on Monday wait on a judge.
All right.
Please let me get to say something about my children. I am afraid of being in this jailhouse without no prescription or psych medicines. So I would like to be at a bark on the outside.
We're ordering a screening right now to address those concerns, okay?
Okay.
All right, good luck, ma'am.
Thank you, Judge.
You're welcome. Can you please prepare the short order for the, oh, thank you, you're ahead of me. Oh, do I need the order for the evaluation? Did you have, okay, thank you so much. You're good?
Just two more.
Okay.
Judge, on page 10 of the docket, right about the middle of the docket that you have this morning, there's a David Lampron. He's...
Okay, just one moment, let me find the defendant's packet. Okay, I do have it.
Judge, he's in the main jail. He's charged with a county ordinance of panhandling, Your Honor. Could I approach, Judge?
It's for me? Thank you.
Say 17, 27. What's your email?
And state, is there an offer? Good morning, sir.
Morning.
Yes, Your Honor, we're asking for an adjudication and time served, court cost.
Are there priors?
Yes, Your Honor.
Okay, you don't have to go into the, are you satisfied with the?
Yes, Judge, I
Okay.
spoke with Mr. Lampron, in custody, Judge, and I explained to him everything about his rights and the charges against him, and he expressed to me repeatedly that all he wants to do is resolve this matter and, get out of the jail.
Okay, the only thing I would add would be, a no return to that intersection.
He nodded his head, yes, Judge.
Okay. All right, can we please place Mr. Lampron under oath?
Sir, please raise your right hand. Sir, please raise your right hand.
Sir,
Do you solemnly swear or affirm that the testimony you're about to give is the truth and nothing but the truth?
Yes.
Please state your name for the record.
David Wayne Lampron.
Thank you.
all right, sir, good morning. It's my understanding you wish to resolve your case today?
Yes.
Okay, and you've been charged with one municipal ordinance, that's for panhandling? Sorry, it's a county ordinance, I apologize. You understand that? Okay. Are you currently under the influence of any medication, drugs, or alcohol that would affect the way you think, sir?
No.
In the past year, have you been treated for a mental illness?
Last year, what, sir?
Have you been treated for a mental illness?
Yes.
Okay, the treatment, did it help the way you understand things?
Yes.
Okay, have you ever been declared incompetent by a court of law?
No.
Do you have any concerns as to whether or not you understand what's going on this morning?
No, I understand.
Okay, and Mr. McLawrence, do you have any concerns for competency?
No, Judge, I don't.
Okay. Sir, and you understand the charges and the maximum penalty is 60 days in jail? Or 6 months probation?
Yes.
And the offer is an adjudication, credit for time served, and court costs in the amount of
This is them.
$293. You understand that, sir?
Yeah, I understand that.
Did anyone promise you anything different?
Pardon me?
Did anyone promise you anything different?
No.
Did anyone threaten, force, or coerce you to take this plea, sir? You understand if I take your plea, you're going to be waiving certain constitutional rights.
Yes.
Those rights include your right to maintain your plea of not guilty and have a trial, your right to present defenses, file motions and pleadings, your right to remain silent, have the city prove your case beyond a actually the state prove your case beyond a reasonable doubt, your right to confront and cross-examine every witness against you, call witnesses on your own behalf, and appeal any prior rulings of this court. Do you understand those rights, sir?
Yes.
And do you wish to waive those rights so that you can take this plea?
Yes.
Are you satisfied with your attorney?
Yes.
Have you had enough time to speak with him?
Yes.
And you understand if you're not a U.S. citizen, taking this plea would subject you to deportation proceedings.
Yes.
Under the Jimmy Rice Act, if this were a sexually violent or sexually motivated offense, or if you previously have been convicted of such an offense, taking this plea would subject you to involuntary civil commitment.
Yes.
And,
Understood.
sir, knowing and understanding everything we've discussed, how do you wish to plead? No contest?
No contest.
Okay, and is there a factual basis? Or are you stipulating to the factual basis based on the probable cause affidavit?
I am, Judge.
State?
Yes, Your Honor.
Okay. Based on the stipulation, then the court's review of the court documents, including the probable cause affidavit, sir, I will find there is sufficient basis to take your plea. Is there anything that you would like to say before I pronounce sentence in your case?
No, sir.
Okay. I will accept your no contest plea. I'll find that you freely, voluntarily, and intelligently entered into this plea with the advice of competent counsel with whom you're satisfied, that you understand the nature of the charges against you and the consequences of taking this plea. And I will honor the agreement. I will adjudicate you of this offense, give you credit for all the time you've served, and assess court costs in the amount of $293. And I will give you 6 months to pay the court costs, sir. And you have 30 days to appeal the court sentence. Good luck, sir.
Thank you.
You're very welcome.
Lastly, Judge, perhaps a few names down from Mr. Lampron is Francis Carr. He's also in the main jail. And he's there, he has some issues with his back, Judge, so it takes him a while to walk.
It's going to take me a little while to find his paperwork as well.
Francis Carr, he's on page 11.
With a C or with a K? Oh, I see it. Okay. Is this a resolution as well?
Judge, this one is a City of Fort Lauderdale municipal ordinance for urinating in public. In speaking with Mr. Carr, Judge, he informed me that he does have a place to stay. He's not homeless, and he does have income coming in from Social Security. And he also expressed to me a desire to resolve this matter.
Do you have a probable cause affidavit?
Yes, Judge, if I could approach.
Okay, and can we please place Mr. Carr under oath?
Sir, please raise your right hand. Sir, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth and nothing but the truth?
Yes, ma'am.
Please state your name for the record.
Francis Clark.
Thank you.
Sir, good morning.
Good morning, sir.
It's my understanding you wish to resolve your case this morning?
Yes, sir.
Okay, you've been charged with one count of urinating in public. The maximum penalty is 60 days in jail or 6 months probation. And does he have any priors?
Yes, Your Honor. It's a long list of both, I mean,
Yep.
the most recent felony he committed was 2004 Otherwisers County Municipal Ordinances.
Okay, thank you.
Yes, Your Honor.
And, sir, the court's offer would be an adjudication and time served.
No contest, Your Honor.
Okay. Are you currently under the influence of any medication, drugs, or alcohol that would affect the way you think, sir?
No, sir.
In the past year, have you been treated for a mental illness?
No, sir.
And you understand at the charges I've read it to you in the maximum penalties?
Yes, sir.
Okay. And are you currently under the influence of any medication, drugs, or alcohol that would affect the way you think?
The doctor gave me some medicine last night to help me sleep.
Are you still under the influence of that medication?
Huh?
Are you still under the influence of that medication, sir?
No, it's okay.
Okay. Do you have any difficulty understanding what we're talking about?
No, sir.
Okay. And you haven't been treated for a mental illness, is that correct?
Oh, years ago.
The treatment, was it found not to be necessary, or is it something you discontinued?
It was not necessary. I was,
You don't have to tell me the diagnosis, sir, that you do have rights, okay?
yes, sir.
Now, have you ever been declared incompetent by a court of law?
No.
And Mr. McLawrence, do you have any concerns for his competency?
No, Judge, I do not.
Okay. Sir, the offer is an adjudication, time served, and court costs in the amount of $78. You understand that?
Yes, Your Honor.
Did anyone promise you anything different, sir?
No, sir.
Did anyone threaten, force, or coerce you to take this plea?
No, sir.
You understand if I take your plea, you're going to be waiving certain constitutional rights.
Yes, sir.
Sir, those rights include your right to maintain your plea of not guilty and have a trial, your right to present defenses, file motions and pleadings, your right to remain silent, have the city prove your case beyond a reasonable doubt, your right to confront and cross-examine every witness against you, call witnesses on your own behalf, and appeal any prior rulings of this court. Do you understand those rights?
Yes, sir.
Do you wish to waive those rights so that you can take this plea?
Yes, sir.
And are you satisfied with your attorney?
Yes, sir.
Have you had enough time to speak with him?
I spoke with him a minute or two.
No. Do you need any more time to speak with him?
No, sir.
Okay. And you understand if you're not a U.S. citizen, taking this plea would subject you to deportation proceedings.
Yes, sir.
Under the Jimmy Rice Act, if this were a sexually violent or sexually motivated offense, or if you previously have been convicted of such an offense, taking this plea would subject you to involuntary civil commitment.
Yes, Your Honor.
And knowing and understanding everything we've discussed, sir, how do you wish to plead? No contest or guilty?
No contest, Your Honor.
Okay, and is the stipulation a still factual basis?
Yes, Judge.
Okay, based on the stipulation and the court's review of the court documents, including the probable cause affidavit, sir, I will find there's sufficient basis to take your plea. Is there anything you wanted to say before I pronounce sentence?
No, sir.
Okay, sir, I will accept your no contest plea. I'll find that you freely, voluntarily, and intelligently entered into this plea with the advice of competent counsel with whom you're satisfied. Do you understand the nature of the charges against you and the consequences of taking this plea? And I will honor the agreement. I will adjudicate you, give you credit for the time that you've served, and it says court costs in the amount of $78, and I will give you 6 months to pay the court costs, and you have 30 days to appeal the court sentence, sir. Good luck.
Thank you, Your Honor.
Thank you, Judge.
You're very welcome.
Okay, take care. Have a good weekend, everyone.
You as well. Okay. Tiffany Denson.
Ms. Denson's here at Main Judge. She is approaching.
Good morning, ma'am. One count of robbery with a weapon has been presented. Are there any arguments from either party?
Just as the bond recommendation, Your Honor.
Yes, sir. Tiffany Denson.
Your Honor, we're asking for a $50,000 bond. That's for no victim contact. And if she does post bond, we're asking for a pretrial release with a GPS monitor.
It's toward, there are several pages before it, but it's after the warrant. It's just before her booking.
Okay.
And Mr. Vincent, while you're there, are there any priors?
Your Honor, she has a West Palm Beach prior. She's actually currently she's on probation for organized fraud out of West Palm Beach. That was a 2016 case. She was charged with the grand theft was no prost, and she's currently on.
She's currently on probation?
Yes, for organized scheme to defraud. Less than $20,000. In 2013, Your Honor, there was a battery and a criminal mischief, and she entered pretrial diversion on those counts. In 2012, there was a domestic battery. It was a withhold, and there was also a cruelty to animals.
Anything further?
If this, when the state's done, Judge, the defense would like to be heard.
Does that conclude?
Yes, Your Honor.
Okay. And yes, Mr. Romero.
Judge, respectfully, and speaking with Ms. Denson, she's been residing in South Florida her whole entire life. She's 30 years old. At this time, unfortunately, she just lost her job. She's currently looking for work. She was working a couple weeks ago at Red Robin's. She was making approximately $12 an hour. She lives in Palm Beach with her husband. Her husband's a cook at Capitol Grill. He's been working there for about 7 years. That is true, Judge. She is in probation in West Palm Beach. She was actually placed on probation after this alleged incident. So this would not be a violation of probation. It happened before she was placed on probation. She's been placed on probation for 18 months. One of her conditions of probation is community service along with restitution. Every month she pays $125 a month for restitution. Right now she has a great rapport built up with the probation officer, Mr. Jean-Pierre. Judge, she's no prior violation of probation. It's on the probation case that she has in Palm Beach. So at this time she's been an excellent candidate as far as supervision, been maintaining regular contact. Judge, from what the state suggested as far as a $50,000 bond is tantamount to no bond on Ms. Denson's behalf, we feel that's not reasonable considering the circumstances. Judge, we respectfully be asking for a $2,000 bond. At this time also, ordinarily I would be asking for pretrial release, but that in a sense would be kind of like a double monitor because she's currently being supervised on Palm Beach. So I see the need for her to be placed on pretrial because if, as you know, Judge, if she violates any of the conditions of her probation case in Palm Beach, a warrant would be submitted, probably holding her no bond. So at this time, Judge, there's every incentive to her to go to court, appear, because if she fails to appear to court, she will have a no bond issue here in Broward as well as Palm Beach. So Judge, we feel a $2,000 bond would be reasonable in Ms. Denson's behalf at this time.
Judge, as to probable cause, they had a contractual exchange for $50 and then for $20 for the ride. The victim is the one that actually did that. No amount of money retrieved is said in the probable cause affidavit, so we don't know if the deprivation of money was part of that contract that they made or whether it was because of the tire iron. So I believe that this is battery, maybe multiple batteries at most, but this isn't a felony since they don't specify that the money taken was the contracted money or additional money.
It specifically says an additional $20 once they arrived in the city of North Lauderdale, after which the defendant, took the victim out of the car and struck her several times with a tire iron before she was deprived of her money by the defendant.
Right, and so the $20 was to go to the check cashing store and the $50 was from the ride from the jail. So that was the contract that they had entered into by the victim's own admission. We don't know any additional money that was deprived. I don't know if the probable cause affidavit just didn't mention if more money was deprived, but that money essentially belonged to her because she performed her aspect of the contract, and so this is a battery, Judge.
Further, it says that the first line says December 5th, 2016, the defendant did intentionally deprive the victim of her property, $245. Whereas the otherwise, it would be $50 and $20 would be the, as our contracted rate for the ride to both the check cashing store.
So noted. I will find probable cause to detain you, ma'am, and I will set bond at $30,000. Order no contact with the victim. And you're already being supervised. I'm not going to place you on pretrial with a GPS. You do not have a Broward County residence. You live in Palm Beach County.
Your Honor, we would just also ask for no victim contact.
I did follow that recommendation.
Yes, thank you, Your Honor. This happened in 2016. I don't know if you could take that into consideration and lower the bond in the lieu of the fact that, you know, this has happened nearly 2 years ago. Well, I guess a year and a half ago.
I did nearly cut the state's recommendation in half, and I also deleted the requirement of pretrial with the.
Understood, Judge.
Good luck, man.
Take care, man. Jarima Holloway.
Judge, if you can put this on recall, the private attorney had asked.
You're gonna be placed on recall, ma'am. Have a seat, Ms. Holloway.
Who was the private attorney?
That I am not sure of.
Okay. Tiana Allen.
Miss Allen, come on up, please.
Good morning, ma'am.
Good morning.
Ma'am, one count of aggravated assault with a deadly weapon has been presented. I do find probable cause to detain you.
Judge, as far as probable cause goes, we do not know if the other person or the alleged victim is the one that instigated this, and because of stand your ground law, the probable cause is actually flipped on its head, where you have to find that there was probable cause that she did not stand her ground. Are you finding that, Judge?
You're asking me to make a determination for an evidentiary hearing at magistrates?
No, people other than, well, basically, people have immunity from even arrest and detention and stand your ground immunity. And so rather than just find probable cause, if it looks as though there's stand your ground possibly as a defense, you have to find that there's probable cause that she did not stand her ground rather than probable cause that she committed the crime.
All right, State, do you have an argument?
Your Honor, this was just first of all, this was a casual encounter between two people over a parking spot. The defendant then retrieved a bat out of the back of the car and tapped it against her hand and threatened to strike the bat to the victim. There's nothing here that indicates that she was standing her ground or that otherwise needed to take out a baseball bat, and otherwise an encounter between two ordinary citizens, Your Honor.
She very well could have been defending herself, Judge.
Very well could have been, Your Honor, but it's pure speculation at this point in time.
At this point, the court would have to agree there, it would be pure speculation to assume otherwise, and based on the actions that are alleged, I don't see any indication of a weapon or any threat made from the victim that would, or the alleged victim, that would suggest that there is violence or violence was imminent. But I do see a weapon that was alleged and the threats that were allegedly made by the defendant. So I will find probable cause. As to conditions of release.
We're asking for a $5,000 bond and no victim contact.
Judge, if the defense could be heard after the state finishes giving their input.
They actually did.
Thank you, Judge. And speaking of Miss Allen, she's been residing in our community for the past 13 years. She is 37 years old. At this time, she is employed. She works at a group home as one of the workers. She's been steadily employed with that company for over 4 years now. She makes $10.82 an hour. Besides that, Judge, she is going to school. She goes to Broward College. She's right now going to school. She's taking 8 credits. She's set to graduate. She only has 4 more classes to go until she actually receives her AA degree. She lives in North Lauderdale with her parents. They've been residing at the same location for about 3 years. Their monthly rent is $787 per month. Her parents are retired. That's the people that she's going to be counting on to post her bond. Because they're retired, they have limited funds, Judge. My understanding is this is her first arrest or first contact with the criminal justice system. She is a registered voter in Broward County. We'd be asking respectfully, because of strong ties to the community, her lack of any sort of criminal priors. I did talk to her. She does have defenses, as my colleague stated, and I told her there will be a time and a date to argue that in the future. I told her today's unfortunately not that day. But Judge, this is a person who's never had contact with law enforcement officers, strong ties. We'd be asking for a $1,000 bond on her case. We feel that would be reasonable and appropriate in that case, and we'd be asking you to sign a phone order so she could access her contacts to see if her parents can't afford how they can come up with a bond of $1,000.
Judge, I also want you to just take note that it says that she was waving the bat around in a threatening manner, as if she were going to hit Mason just a few feet away. it doesn't say what that threatening manner is. It doesn't say in any shape or form. And I see nothing as far as imminent or aggravated assault of hitting your hand with a bat, possibly in self-defense, or just saying that if she were attacked, that she would be able to rebuff it.
Understood, and respectfully, I did allow the probable cause argument to be made, and the court has already ruled on that. And I will stand by the ruling. I will set bond at $5,000 and order no contact with the victim. Ma'am, no contact means no direct, indirect, telephonic, electronic contact by any means. I am concerned only because they both appear to be students at the same school. Ms. Romero, so please make sure that she understands the no contact order.
I will, Judge, and as far as the phone order I requested?
I will. I did receive two, but they didn't reflect the language that I indicated, that she may be permitted to view her phone for the purposes of obtaining phone numbers or contact information, but it'd be under the supervision of law enforcement. So she can view her phone. I can't order that her phone be turned over to her while she's in the jail. Well, the orders that I previously received shall be permitted access to her phone, to access the phone and property. That order I wouldn't be able to sign that, so I need the orders to reflect that under the supervision of law enforcement, that she can view her phone for the purpose of obtaining contact information.
Yes, Judge, so you are,
Yeah, I will sign.
that motion.
I will grant that request, absolutely.
Okay.
I just need, the language is the concern because otherwise,
Under the supervision
as written, it just has me turning phones over to inmates, and that would create an issue, and
believe me, that's not gonna happen.
I just want to make sure that by my order, it's not done, so. But thank you, Mr. Romero. And good luck, ma'am. Do we have Lexa Katz?
Medical research, Your Honor.
Oh. Katz. Miss Lexa Katz. Okay, do we have Julie Becker?
Yes.
Good morning, ma'am.
Good morning, sir.
How are you?
Disturbed about this case.
All right, keep in mind, everything you say is being recorded, ma'am.
Yes, sir.
Okay, and I advise you that only because it could be used against you at a later date, okay?
I understand.
One count of exploitation of the elderly in an amount less than $20,000 has been presented. Ma'am, I do find probable cause to detain you. And as to conditions of release.
State's asking for $25,000 bond,
I'm sorry?
$25,000 bond.
Judge, she's a 46-year resident of South Florida. She's on Social Security, and being incarcerated will cause her benefits to be suspended. She has children that she's raised. She would reside with her partner in Hollywood, and she can't afford more than $5,000 bond, and so we're asking that you set it at $5,000 and allow her to have a day in court to contest it.
Further asking for no victim contact with pretrial release and GPS. And, Your Honor, just in regard to the allegation in the case, it says that she took there's apparently $13,000 in transfers from the defendant's account.
The victim's account?
From the victim's account, Your Honor. And it would just
A 46-year resident of South Florida and someone on Social Security doesn't need a GPS monitor for a financial crime.
I was prepared to lower it and order the GPS, but then as it stands, I will honor the state's original recommendation in part, and I will order the bond be set at $25,000 and no contact with the victim.
Judge, why such exorbitant amount? She's gonna have to pay us $2,500 for one charge.
Based on the facts and circumstances presented in the probable cause affidavit.
I don't know if I have that, but okay.
Yolanda Little.
Miss Little is approaching, she's here at Main, Judge.
Good morning, ma'am.
Good morning.
Ma'am, one count of grand theft has been presented. I do find probable cause to detain you. Are there any arguments as to conditions of release?
Not from the state, Your Honor.
Judge, Miss Little informed me that her mother is gonna be posting her bond.
Okay, I will set bond at $1,000 and order no return. Good luck, ma'am. Suzanne Coughlin.
Yes, sir.
Good morning, ma'am.
Good morning.
Ma'am, one count of resisting an officer without violence and one count of tampering with evidence has been presented. And I will find probable cause to detain you. As to conditions of release, do you have argument from either party?
No, Your Honor.
What was that? What was that?
Right now, I found probable cause to detain you, and I asked both the state and defense whether or not they had any arguments as to conditions of your release, ma'am.
Judge, we're just asking that you keep it the same.
I'm on disability.
Okay. Ma'am, I will set bond, I'll ROR you on count one, and set bond on count two at $1,000.
Okay.
Good luck, ma'am.
Thank you, sir.
You're very welcome. I'm sorry. Oh, okay. Michelle Lang.
Miss Lang is present here at Main.
Good morning, ma'am.
Good morning.
Ma'am, 7 counts have been presented. They include possession of cannabis with intent to sell or deliver, possession of cocaine, trafficking in oxycodone, more than 7 grams and less than 14 grams, possession of amphetamine, possession of THC, possession of drug paraphernalia, and child neglect. And ma'am, I do find probable cause to detain you.
Judge, I just ask you to take in consideration that the brazenness of this probable cause affidavit, that they are responding to something totally separate from this, and simply because the door was open, they enter the residence for no reason that they make apparent in this, and then go into a south bedroom where they find the child and the cannabis and other things, bongs, paraphernalia. I understand that they did get a warrant after the fact, but it was based upon
The entry based on a shooting at the location.
well, no, it wasn't at the location. A possible shooting at the above location. That
Okay.
doesn't. There was no confirmation. We don't know if it was a citizen informant, but in any case, they just walked right into their residence.
It indicates that they did so after being informed that there was a 6-year-old that was possibly alone, or they couldn't confirm if there's anyone else in the residence.
Well, they just said it was determined that there was a 6-year-old juvenile after they stormed into there and found him in the south bedroom, and after they violated her
No, it
rights. for
actually
home.
indicates that after this, they were made aware of the 6-year-old. That's when entry was made, because of the 6-year-old. It was in the residence of an area where there was a possible shooting, and they were not aware whether or not the 6-year-old was alone.
It says it was determined that a 6-year-old juvenile, so they determined it, not they were informed.
And then read
of it.
this sentence later after that.
Okay.
It was only then that the allegation is that entry was made.
I don't understand, Judge. What I'm saying is that it was determined that a 6-year-old juvenile was still inside the residence. They didn't say how, they didn't say why.
No, I understand. I understand, that part I understand, it's the time frame, but the determination was made before the entry pursuant to the allegations.
It was before the entry? Like, how did they determine that?
And that's,
Okay. Okay.
so they arrived on the scene, they noticed the front door, and I can read the entire probable cause affidavit into the record if necessary, but I do find that there is probable cause to detain her. But as to the conditions of release, though,
Just ask that you take that entry into her home into consideration whenever you set bond, because she probably has a very good constitutional argument when the Fourth Amendment's at its zenith.
oh no, I understand that there may be a motion to suppress issue at a later date, but we're not here for a motion to suppress at present.
Of course, but you can take that into consideration when setting bond over $80-some-odd thousand.
Oh no, I understand, but I do also take note of the first few sentences indicating the reason for their arrival at scene. But I've heard argument from defense and now as to state.
Yes, Your Honor, just in addition to the bonds that are being set through charges number 1 through 6, we would ask that on count charge 7, the neglect of child without bodily harm, there be a bond set in the amount of $5,000. You know, just based on the fact that, you know, all the drugs and paraphernalia that was found on top of the dresser was also in the same bedroom within feet of the 6-year-old child in this case. And in addition, there was candy next to the drugs and paraphernalia that was also found.
Judge, it says dresser, not nightstand. Dresser is probably without reach of a 6-year-old.
Well, they indicated 6 feet was the estimation.
This is reaching for child neglect. I mean, I understand that there's candy beside there, but this is really reaching. I'm just asking you to set $1,000 bond. And I'm sure Mr. Romero may have some information as well.
Also, she has a pending grand theft out of Osceola County.
Any grant theft from another county.
Yes, Your Honor, it's been filed.
Mr. Romero, did you have anything to add, sir?
I do, I just wanted to make sure everyone finishes, like, the state of pretrial, if they had any input.
Well, and actually, defenses had input as well. I've actually technically heard from all parties, but I will allow you to speak as well, Mr. Romero.
Judge, in reference to the bond, I understand as far as Ms. Lang, she's 25 years old. She's been residing in Florida her entire life. At this time, she is working. She's a receptionist. She obtained that employment approximately 5 months ago. She's making about $12 per hour. She's also going to school. She goes to Florida International University. She's studying administration. She lives in Fort Lauderdale. She is a single mother. She lives with her boyfriend and a roommate. They share the expenses and where they live. It's about $1,500 per month. They just moved into the location about 2 months ago. They did sign a lease. So they have a lease agreement for the next year. So it's not like she's renting there from month to month. She actually has a lease. Her boyfriend is a person that she's going to be counting on to help her post her monetary bond. Her boyfriend works at Lowe's. Her boyfriend makes approximately $10 an hour. So the bond, which is currently set on count 3, especially, Judge, at $75,000, I'm thinking it's probably going to be over 10 years of him working continuance before he can even manage to come up with those funds, Judge. By then, Ms. Lang will probably be 10 years older. Judge, at this time, we'd be asking you to set a reasonable bond. I'd ask you to take my colleague's argument for mitigation purposes as far as count 7 relating to there's 2 sides to the story. What was written on the PC affidavit, I did explain to Ms. Lang, is what this court has to go by at this time, but there was a lot of things that were omitted in that PC affidavit. Judge, we'd be asking you to consider reducing the bond on count 3 from $75,000 to $7,500. On count 7, Judge, we'd be asking you to set $1,000. So therefore, our 2 bond requests are specifically made as to counts 3 to $7,500 and count 7 to be set at $1,000.
Your Honor, just to briefly respond. In the bedroom, this, number one, it's a trafficking oxycodone charge, which obviously is a trafficking case, which, you know, is drug possession, distribution, that would bring in all kinds of illicit money, which wouldn't come from a normal job working a 9 to 5, Your Honor. In addition to that, it's a possession with intent to sell or manufacture cannabis, which is also a drug distribution charge. Your Honor, on top of that, the PC states that the defendant admitted to spending $1,200 a month on marijuana by itself. In addition to that, there's 26 alprazolam, 110 grams of marijuana, crack cocaine, 4 grams of hashish oil, 65 Adderall, 14 oxycodone. Your Honor, just based on these facts, we ask that the standard bond amounts that are currently posted on charges 1 through 6 stand, and that the bond amount on charge 7 be $5,000, Your Honor.
All right. I've actually heard from the state twice, from the defense twice, and I'm ready to rule at this juncture.
Well, that's why, Judge, I wanted to go when everyone was done. That's why I specifically said it. I didn't want to interrupt anyone.
Mr. Romero,
brought in additional information.
Mr. Romero,
That's why I waited.
your colleague already addressed the case?
The PC affidavit.
No, he
addressed as far as for probable cause.
he also addressed bond. He addressed bond as well.
I didn't address bond, Judge. I had said take into consideration the probable cause weakness and the possible motion to suppress in that, but I have no individual information. I don't talk to her on the other side.
Okay. All right. Respectfully, I did allow all parties to be heard, and I will set bond on count 1 at $1,000, count 2 at $1,000, count 3 at $75,000, count 4 at $1,000, count 5 at $1,000, count 6 at $100, count 7, $1,000, and on count 7, actually on all counts, standard pretrial, and special condition, follow orders of dependency court. And if no orders are made of the dependency court, or if there's no finding and it is not sent to a dependency court, obviously that condition would no longer remain. Good luck, ma'am. David Wayne Carroll.
David Carroll's here at Maine, Judge. Come on up, Mr. Carroll. Carroll. Mr. Carroll's hard of hearing, Judge, so if you could speak closer to the microphone.
Mr. Carroll, can you hear me, sir? Mr. Carroll. Mr. Carroll, can you hear me, sir?
What's he saying?
He's saying, can you hear me?
No.
Okay.
I can hear you a little bit, but I can't make out what you're saying.
Where's the microphone located?
Quiet.
Mr. Romero, where's the microphone located?
Your microphone? I believe it's in front of you.
The speaker. Where's the speaker located?
Oh, the speaker, it's on the TV, which is approximately,
He can.
I believe, 10 feet from us.
Okay. Can you take a step forward?
Who?
Your client.
Take that microphone in front of you and pull it closer to you.
Can you hear me now, sir?
Yeah, a little bit.
All right. Now can you hear me, sir? I've turned the microphone up as high as it goes.
Yes, I can.
Okay, sir, you have a capias on a misdemeanor case, and your bond has been set at $250. You have a hearing before your assigned judge on January 22nd at 1:30 p.m. Good luck, sir. And I do find probable cause to detain you.
Judge, Mr. Carroll is asking me, in my previous conversation with him, to ask you if you would consider releasing him ROR. When he indicated he went to court on this case, he was informed that his name was not on the docket. He came to the Broward County Courthouse. He doesn't remember what date or what time or what courtroom number is, but he said he went. I did tell him he has a future court date of January 22nd at 1:30 p.m. He's asking to be released ROR so that he can attend the January 22nd court date. He is homeless. He can't afford the $250 bond.
Do we have any indication at all as to when he went to the courthouse?
I tried to get that information. He said he couldn't remember.
Last week? Last month? Last year? A decade ago?
Let me inquire.
Let him know that you want to call him, because I told him not to call him.
Over a month.
He said it's been a little bit over a month, or specifically he said over a month.
All right. This warrant was issued on December 28th. So he did not go when his court date was scheduled. I will respectfully decline the request and leave the bond set as previously set by his trial judge. There is a hearing on January 22nd at 1:30 p.m. where he can address that matter.
Yes, Judge.
Calvin Sims.
Mr. Sims, come on up, please.
Mr. Sims, good morning, sir.
Good morning.
Sir, 2 counts have been presented. 1 count is battery. The other count is disorderly intoxication. Sir, I do find probable cause to detain you. As to conditions of release.
Your Honor, we asked for a $1,000 bond that's currently set on count 1. We're also asking for pretrial release with a GPS monitor and no contact with the victim.
And defense.
Is the state finished?
Yes. Thank you.
Mr. Sims, judge, has been residing here in South Florida his whole life. He's 46 years old. He's currently working, just obtained employment at Arctic Air Automotive. He just started. He's making approximately $10 an hour. He's been working there for 3 months. He's living in Fort Lauderdale. He rents a house with his roommate. He's been living there for about 2 years. They share the expenses. His portion is about $600 per month. At the end of paying his portion, he basically has zero money left, only for food, things of that nature. Judge, he said his roommate is not in a financial position to post his bond. He's asking if the court would consider releasing him on pretrial release.
Does he have priors?
He had a prior battery that was dropped in 2013, battery 2011 that was adjudicated withheld, shoplifting 2010 conviction, another battery that was no process 09, aggravated assault with a deadly weapon, and another battery on a pregnant female 09 that was dropped.
Can we stop hearing the null process and the drops?
For batteries, I think we're allowed to.
I'm allowed to hear them.
Just please don't take them into consideration.
This isn't sentencing, it's not a score sheet issue. But
So you're telling me that people are
I'm
assumed
just-
guilty at magistrate?
I did not say that, counsel.
So I don't understand what the difference is.
Okay, you may proceed.
Leaving the scene of an accident, 2001, conviction, possession of cocaine with, delivery of cocaine, 1998, sorry, withheld. He has 4 failure to appear.
4 failures to appear, okay. I will leave bond at $1,000 on count 1, 0 on count 2, no contact with the victim. Good luck, sir. Ryan Longinos.
He's approaching. He remain.
Sir, good morning.
Good morning, Your Honor.
Sir, you have two counts that have been presented. Let's see. Count one is a criminal mischief, and you have a warrant on case number 17005974 MM10A. It looks like the bond has been set at $500 on that. I do find probable cause to detain you. And any arguments as to count one?
No, Your Honor.
Defense.
Judge, in reference to PC, that would be my colleague. I don't know if he has anything.
I mean, as far as the argument of probable cause, the officer can arrest him for a misdemeanor that happened outside of his presence, whether it was on video or not, but because of in light of the fact that he discovered a warrant, I believe that Utah versus Streif says that the illegal detention has been attenuated by the finding of a subsequent warrant, so it moots out my probable cause argument as to the illegal stop.
Judge, if Your Honor has.
Mr. Miro, I can't hear you, sir.
Mr. Longino advised me his parents know he's here. They're going to be posting his bond.
Okay. Bond on count 1, 25. Count 2 has previously been set at 500. And you have a hearing before your assigned judge on January 22nd at 2 p.m., sir. Daniel Parker. Good morning, sir.
Good morning.
So you're here for one count of trespassing after warning.
Okay.
I do find probable cause to detain you, sir.
Is there any way that we can resolve the issue today? I did just start a new job. This comes out of homelessness, and I'm just trying to do better, man. That job's gonna help me tremendously to get off the streets right now. Trying to get into a halfway house, need the money.
Other prior state?
Six pending municipal ordinance cases,
Sorry.
as well as a third-degree felony.
It looks like you have several other cases that are pending that I don't have before me.
Well, like I said, they're coming out of being homeless, like lodging and
Sir,
stuff like that.
keep in mind, everything's being recorded. I want you to keep that in mind, sir.
Okay.
Because of the 6 other cases, I do have a concern also. If you resolve this case, you may be on a condition of bond or release on any of those cases. And your bond could be revoked by your trial judge. I'm not taking action on that, but it could wind up happening. Okay?
Well,
if you resolve this case today, the admission would also be able to be used against you in a bond revocation hearing. Okay?
Okay. Yes, sir. But I would, if I can resolve this and get back to that job, I would be able to take care of these things
Judges.
a little bit more accurately.
In further support of your position, Your Honor, he does have a felony pending for battery on a person over 65.
14 months ago.
Sir, again, you may not want to speak about any other cases, but I will decline to resolve the case today. I'm going to set bond at $25, and you will have a hearing before your assigned judge, sir. Good luck, sir.
Okay, do you know when that will be?
I don't have it as of yet. It has not been set, but I'm asking that it be set as soon as possible.
Judge, I'm asking that you find non-monetary basis.
MO case? You are?
Oh, I didn't know it was an MO. My fault.
Okay, thank you.
Good luck, sir. Dominic Gonzalez.
Mr. Gonzalez is approaching. He's here at main, Judge.
Mr. Gonzalez, sir,
Yes, good morning, sir.
how are you?
All right, how you doing yourself?
Doing well, sir. You have one count of trespass, failure to leave after being asked by the owner. I will find probable cause to detain you, sir.
Mr. Gonzalez did inform me he's going to be posting his bond. Judge.
Okay, bond is set at $25.
Good luck, sir.
No return.
Yes, sir.
On Robinson, do we have the warrant?
Robinson, come on up.
Is this a failure to appear warrant? Or if there's a probable cause affidavit, I don't have one that's been presented.
See affidavit, Your Honor?
I don't have a probable cause affidavit. Is this a failure to appear warrant or?
Yes.
For the other court date on January 22nd.
Okay, and bond has previously been set at $250. Okay. And, Judge Williams' order? $250, okay. So I will honor Judge Williams' order, sir, and, your bond will remain at $250.
Good
Good
luck,
luck,
sir.
sir.
Inform me his grandmother's posting his bond.
All right, thank you, Mr. Romero. Do we have Craig Baez?
Come on up, sir.
Good morning, sir.
Good morning, Your Honor.
Sir, one count of battery has been presented. I do find probable cause to detain you as to conditions of release.
Your Honor, we would just ask for the bond that's currently set, stand, $1,000. We ask for no victim contact. We ask for a pretrial release with a GPS monitor.
All right.
Sorry.
Defense?
Judge, and speaking Mr. Baez, at this time, he's homeless. Whenever he can, he works as a day laborer, so if he can find employment, he gets paid approximately $50 per day. He's 51 years old, been living in our community since 2010, so about 8 years now. At this time, Judge, he did advise me that he has a mailing address where he can get notices. Judge, considering he's financially indigent, we'd be asking you to consider releasing him on pretrial release. So therefore, he could basically fight this case from outside, Judge.
All right. I do see the nature of the allegations, and I will set bond at $1,000. I will also order no contact with the victim.
Judge, would you also sign a photo order so we could photograph Mr. Baez's injuries?
That I would.
I got to stand for that. Do you need me to do it?
Stefano Alexandre.
Mr. Alexander, come on up.
Sorry? Oh. Thank you. All right. Sir, you have two warrants, both in the same case number 170-10695 MM10A Bond has been set at $500 on each count, and you have a hearing before your assigned judge on January 18th at 2 p.m. Good luck,
The
sir.
only thing we're gonna be requesting is a phone order so we can contact his mother to post his monetary bond.
Okay, I will sign an order similar to the ones that I've previously requested the language, but I don't have any that have been presented as of yet.
Yes, Judge.
Sean Collins.
Mr. Collins, come on up, please.
Mr. Collins, sir.
Good morning.
Good morning, sir. You have a capias that's been issued on case number 17004741, MM40A, and the bond has been set at $500.
Judge, Mr. Collins is asking me to ask the court if you would consider resolving this case for time served.
I don't have a probable cause affidavit, and it is a trespass. I'm not sure what kind of trespass it is. If it's if there is a victim and if contact has been made with the alleged victim.
I believe is at Publix in Hollywood.
They're locked up, hold on. Taking care of four of them. Yeah, youngster.
Okay.
Yeah, I'm just trying.
Based on what I've heard, I don't know if anyone's contacted Publix. I don't know if the items have been returned. I don't know if they've expressed their wishes.
What items?
Judge, this isn't a petty theft, it's a trespass. There wouldn't be any items, this
Oh,
is,
well, it's still a victim crime though. That's,
What?
Judge, it's a business, I'm sure we can. Judge, my understanding is if there's a PC affidavit, it can be accessed through Odyssey. I believe he was sitting at a park bench and did his sweep. There was 4 other gentlemen arrested with him. Judge, I just asked you at this time, he's financially indigent, doesn't have the $500 to go ahead and post his monetary bond. We'd ask you at this time to consider resolving his case.
I don't have a probable cause affidavit.
It can be pulled up in Odyssey. I don't know if you have access to a computer. I know the state's there. They typically have printer right there. They can print one up. It could be like another 20 seconds to deal with this guy.
It won't be another 20 seconds, Mr. Romero, but I can
Review the PC.
to review the PC, but I'll address it if I can. I'll look at the PC.
Thank you.
It's the only thing I can promise you.
No, of course, if you read in, the court determines you can, that's the court's prerogative, but.
I'm providing you a copy, Your Honor.
I do need the order to reflect.
Just for the record, Your Honor, there also is a pending misdemeanor trespass before Judge Miller at South.
Oh, this is an MO case? Oh, okay,
Is this the MM4? I apologize, Your Honor.
okay.
I got both.
And
I have both, Your Honor.
I need the phone orders to indicate that she'll be permitted to view the telephone under the supervision of law enforcement for the purpose of accessing numbers. To just access the phone and property would be to turn it over. So I can't do that. That's what I stated on the record earlier.
Sentence.
I'm just asking that the orders reflect, we can do it at the end of the docket if you wish, but I do need the orders to all reflect that. It's not, I'm not well, actually, none of the orders, I'm not actually giving them access to the phone. I'm giving them the opportunity to view the phone under the supervision of law enforcement for the purpose of obtaining contact information. think that's already been made aware. Um, Mr. Vincent, did you have anything? No, Mr. Collins?
Mr. Collins, Your Honor?
Yes.
No.
I'm sorry, do I have both probable cause affidavits?
You have both for the MOA and the MM, Your Honor.
Okay. The MM40A was alleged incident date of 9/19. Is that correct?
Your Honor.
Okay. All week I've been having the orders and that I haven't had an issue, but it was it shall be allowed to view the phone under the supervision of law enforcement for the purpose of obtaining contact information. This is the first time I've had to have the rewrite. I understand that, but I did pronounce it on the record. That's why I took time to do that. But Mr. Romero, or Mr. Collins, I understand you're asking me to resolve the case. There's another case that was presented by the city, and it's at the same location. And I indicated that this is a victim case. It's not the average trespass. The allegations, and sir, please don't respond, are that he has been warned and keeps returning to the same exact location. This may be an issue where supervision may be appropriate. I don't know, but I think it would be best suited to be heard by a division judge if there are other issues that need to be addressed. Because even if I address this case, it would wind up violating a condition of bond on the city case. Actually, no, I would not, but the city case came after. The city case, it was at the exact same location. So respectfully, I will leave bond at $500 as it was assigned by his division judge.
Yes, Judge. Good luck, Judge.
And Ronald Viscuso.
Judge, he's here present municipal ordinance case.
Yes, Your Honor.
Good morning, sir. How are you?
Good morning. Your Honor.
Sir, you have a capias that's been issued in case number 17004219, MO40A. And
Which is a loud stereo.
bond has been set at $25, sir.
Yes, Your Honor. Your Honor, the reason why I didn't appear is because they gave me Dana City Hall to appear, and it was a Fort Lauderdale that I was supposed to appear in courtroom, so it's misunderstood. It's only for a loud stereo. I had called the police yesterday in regards to a breaking and entering in my house. Didn't know that there was a warrant for my arrest. tried to address that with
Sir,
Dana.
sir, everything that you say, and I've been advising everyone this morning, please, everyone who's at every facility, understand that you are being recorded. Everything you say is being recorded.
Okay,
So if you're talking about the facts of your case, it can be used against you at a later date.
I don't have any property on me. The police officers made me leave all my jewelry, my property. I have no means to bond myself. Can I get time served on this, Your Honor? If not, can I pay the fine or get a new court date?
The bond is $25, sir.
I know, but they made me leave all my phone and everything I have at the house when the police officer came to my house. I have no means to call anybody to get out on a $25 bond for a loud stereo, Your Honor. If you give me another court date, I'll show up. If you give me a fine, I'll show up. I'll pay it. But I have no means to bond myself. I have nothing on me to contact anybody. The officers leave everything at the house.
Where do you reside, sir? Where do you reside, sir?
I have a condo at the address that, 541 Southwest 58th Manor, Fort Lauderdale, Florida, 33312.
Okay, that's not the address that we have.
I know, I'm bad, I'm dyslexic, so sometimes I mix up numbers.
They have 2543 Southwest 58th Manor.
Yeah, that's it, Your Honor. That's it. I'm dyslexic, so I mix up numbers sometimes. I'm on a year lease.
Now,
On a year lease.
sir, is there an apartment number?
No, it's a condo.
Is there a condo number? Or
That's
is
the
2543 is the number?
Yeah.
All right, I'm gonna RR you, sir.
Thank you. I really appreciate that, Your Honor.
Good luck, sir.
Thank you.
We have Kerry McCoy.
Mr. McCoy, come on up, please. He's approaching, he's here at me.
Mr. McCoy, sir, you have a warrant for your arrest on case number 17024-284 TC20A. And bond has been set at $250, sir. I apologize.
Mr. McCoy is asking if the court would consider resolving his case for time served today.
I don't have anything on his case, so I can, your previous request about this afternoon is more than likely going to be denied, but I will ask for a probable cause affidavit on this one, or a citation if that's the case. We have a deal?
Yes, pulling that up right now, Your Honor.
I think
Okay.
we have one. All right. State, is there an offer?
Yes, Your Honor, the offer will be a withholding court cost.
Judge, he wishes to accept the state's offer.
All right. Can we please place Mr. McCoy under oath?
Sir, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth and nothing but the truth?
Yes, ma'am.
Please state your name for the record.
Tariq McCoy.
Thank you. You may put your hand down.
All right. Mr. McCoy, sir, you have one count that's been presented, and that's operating a motor vehicle without a valid driver's license.
Yes, sir.
It looks like a permanent suspension. You understand that?
Yes, sir.
Or it's indefinite, I should say. The offer that's been relayed is a withhold of adjudication and court costs in the amount of $293. Do you understand that?
Yes, sir.
Okay, are you currently under the influence of any medication, drugs, or alcohol that would affect the way you think, sir?
No, sir.
In the past year, have you been treated for mental illness?
No, sir.
Okay, and you understand the maximum penalty on this offense is 60 days in jail or 6 months probation. That's not the offer, though. The offer is a withholding court cost. Okay.
Yep.
And did anyone promise you anything different, sir?
No, sir.
Did anyone threaten, force, or coerce you to take this plea?
No, sir.
You understand if I take your plea, you're going to be waiving certain constitutional rights.
Yes, sir, I understand.
Sir, those rights include your right to maintain your plea of not guilty and have a trial, your right to present defenses, file motions and pleadings, your right to remain silent, have the state prove your case beyond a reasonable doubt, your right to confront and cross-examine every witness against you, call witnesses on your own behalf, and appeal any prior rulings of this court. Do you understand those rights?
Yes, sir.
Do you wish to waive those rights so you can take this plea, sir?
Yes, sir.
Are you satisfied with your attorney?
Yes, sir.
Have you had enough time to speak with him?
Yes, sir.
And you understand if you're not a U.S. citizen, taking this plea will subject you to deportation proceedings.
Yes, sir, I understand.
And under the Jimmy Rice Act, if this were a sexually violent or sexually motivated offense, or if you previously have been convicted of such an offense, taking this plea would subject you to involuntary civil commitment.
Yes, sir.
And sir, knowing and understanding everything we've discussed, how do you wish to plead, sir? No contest or guilty?
No contest.
Okay, and state, is there a factual basis for stipulating to the citation?
Yes, Your Honor. On May 18, 2017, at 8700 Wiles Road, Coral Springs, Broward County, Florida, the defendant was driving without having a valid driver's license.
Is there a stipulation?
For purpose of plea, yes, Judge.
Based on the stipulation of parties, recitation of the facts, courts review the court documents, including the citation. Sir, I will find sufficient basis to take your plea. Is there anything that you would like to say before I pronounce sentence?
No, Your Honor.
Okay, sir, I will accept your no contest plea, and I'll find that you freely, voluntarily, and intelligently entered into this plea with the advice of competent counsel with whom you are satisfied. You understand the nature of the charges against you and the consequences of taking this plea. And sir, I will honor the agreement. I will withhold adjudication. It says court costs in the amount of $293. And I'll give you 6 months to pay the court costs and 30 days to appeal the court sentence, sir. Good luck.
Okay, Your Honor.
Mike Felix.
I've been appointed bonded.
Okay, I do find probable cause to detain him. Bond is $500 and he is posted. Gregory Jean.
Mr. Jean, come on up.
Good morning, sir. Sir, 4 counts have been presented. Resisting without violence. Let's see. Municipal ordinance violation. Pedestrian crossing at a right angle. And pedestrian leaving a place of safety.
Judge, I have a probable cause argument when you have time.
As to which count?
As to the resisting or the obstruction officer without violence.
Okay, yes, sir.
Case DH versus State, 121 Southern 3rd 76, 2013, out of the 3rd District, stands for the proposition that just smelling marijuana in a general area is not enough to give cause to detain somebody. You have to have individualized smell of cannabis emanating from that individual. And since the probable cause affidavit does not list that, there is no lawful duty for him to obstruct or oppose. I'm asking that he find no PC or in the alternative ROR based on that. In fact, it's not illegal to run.
State?
Your Your Honor, and the officer was, as they were passing by the scene, they were conducting a lawful investigation based on the odor of cannabis in the air. Upon conducting their investigation, they went to the scene of the scent, the odor of cannabis, and upon responding to that scene is when the crime occurred, which was resisting, which was fleeing and obstructing the officer's lawful investigation. And in the DH case, Your Honor, the conduct that was alleged to have been illegal was a pat-down search just based on an odor when nothing was seen. That's not what happened in this case. This isn't a possession case. This is just a resisting case based on obstruction the officer's investigation, Your Honor.
All right, and I also note, the court also notes the violation for being in the park at night after hours. So at this juncture, the court will find probable cause to detain you, sir. As to conditions of release,
Judge, from the defense, I'd ask you for mitigation purposes to take into account my colleague's argument if you would consider ROR.
the argument as to that basis is for a different purpose, but also the court is finding there was also an investigation based on the being at the park after hours, after operation. So that's why I did find probable cause, based on the totality, not just one limited issue that it's reserved for a different purpose. But are there any circumstances in relation to your client?
Judge, I just, if this is a nonviolent offense, I'd ask you if you would consider a straight ROR.
Does he have any priors?
Possession of cannabis, Your Honor, in 2017. It's currently pending out of the North Satellite, Your Honor, and other than that, in unlawful speed, that's, no.
When you say pending, has it been filed?
That case has been filed, Your Honor. Apparently, he was determined to be ineligible for MDP today, but he did attempt to sign up on the 3rd of January.
All right, I'll reduce bond on count 1 to $50. ROR 2, 3, and 4.
Just for the record, let me I wanted to correct myself. It says on Odyssey that the client is eligible to enter MDP, but he must return in 30 days. So I don't want to.
Mr. Merrill, please let him know about that MDP program.
I will. Thank you, Judge.
Dennis Stevenson.
Mr. Stevenson is approaching.
Good morning, Mr. Stevenson.
Good morning, Your Honor.
Any arguments from counsel?
Your Honor, in terms of bond, we're asking for a $50,000 bond with pretrial release level 1 and a GPS monitor.
Judge, as far as bond amount, in speaking with Mr. Samuel, he's been in custody since December 14th. He's being held on other matters. He's 20 years old. He lives with his grandfather, resides in Miami. At this time, he and his uncle work together. They wash cars for a living. From what the state is suggesting, he can't come anywhere close to that bond amount. He can't even afford the bond amount he's currently being held on. Judge, we'd be asking you to request a $5,000 bond on this case.
All right, State. Was the car actually taken?
No, Your Honor, it appears that the car was not taken.
So this was an attempt?
Yes, attempted to take his vehicle.
So attempted carjacking rather than carjacking, is that correct?
Yes, that appears to be the case, Your Honor.
All right, we'll find probable cause on attempt. And I will set bond at $40,000. No contact with the victim. Good luck, sir. Calvin Harris.
Paul Ryan, Your Honor. How you doing, Your Honor?
Doing well, sir. How are you?
All right.
Let's see. You have 3 counts that have been presented today. I see a burglary of a dwelling that was presented, 2 violations of probation. The violations of probation have no bond holds. As to count 5.
Judge, I have a probable cause argument.
Yes, sir.
This is a business, and it's different than a standard dwelling. It's an invitee situation where people have access to the walkway to come up to the business. So it doesn't say anything that he was outside of the fenced area or the general public access area of that. The second part is that it doesn't say that he actually made entry into the place, and so because he didn't make entry into there, it can't be a burglary. This is a criminal mischief, over $1,000. There's no indication that it was surreptitious or, in fact, it was capricious. It was open, obvious, and so there's no presumption as far as entry into there. It says nothing about his entry, so I ask that you not find probable cause to burglary and 5 criminal mischief to $1,000 since the state can't carry that.
See?
Yes, Your Honor. It says, the PC affidavit states that the defendant approached a closed victim business, had a tiki torch-like object in his hand, which he entered the curtilage of the closed business without permission, again, hitting the front glass door with a tiki torch. This was observed by a witness, and a struggle ensued with the item that was being banged against the glass. Your Honor, he did not have permission, and afterward, he did not have permission. He entered the property and attempted to break into the closed business, Your Honor.
So I didn't hear any refute of that.
Court will find probable cause on the lesser charge of burglary structure. And I will set bond at $2,000 on count 5. And count 6 and 7 have already been set at no bond.
Sir, can I speak?
Yes, sir. You also, before you say anything else, you have a hearing before your assigned judge on January 17th at 9 a.m. But yes, sir.
Sir,
keep in mind everything has been recorded, so don't go into the facts of the case.
And sir, we can't lift the violation of probation holds here, so you're best to just save anything for your counsel on the division. I'd recommend that you not speak at this juncture.
Did you hear that, sir?
Yeah, I heard.
Okay, that was counsel speaking to you, so that you've got advice of counsel not to say anything, but if you wish to say something, it is your right. But again, the court's advising you that you're being recorded, and it could be used against you.
I listen to counsel.
Okay. All right, sir. Again, your hearing is January 17th at 9 a.m. Good luck. Dallas Ware.
Where's your main?
Sir, good morning. You have a no bond hold and a violation of probation on case number 16005323 CF10A. And you have a hearing before your assigned judge. I do find probable cause to detain you. You have a hearing before your assigned judge on January 17th at 8:45 a.m., sir.
Good luck as well.
Good luck. Johnny Anderson.
He's approaching your main.
Mr. Anderson, sir, good morning.
Good morning, sir.
Sir, you also have a violation of probation on case number 16007345 CF10A. And I do find probable cause to detain you. The bond has been set at no bond.
Yes,
and you have a hearing before your assigned judge on January 17th at 9 a.m.
Yes, sir. Good luck.
Good luck, sir. Michael Summers.
Morning, Your Honor.
Good morning, sir. Sir, you have a violation of probation that's been presented on case number 160000105 CF10A. Bond has been set at no bond, sir. And you have a hearing before your assigned judge on January 17th at 8:30 a.m., sir. Good luck.
Thank you, Your Honor.
I do find probable cause to detain you. And let's see, we have Keon Thompson.
No problem.
Good morning, sir.
Good morning, Your Honor. How you doing, sir?
Doing well, sir. How are you?
I'm doing okay.
Sir, one count of aggravated battery has been presented, and sir, I do find probable cause to detain you. As to conditions of release,
Your Honor, we're asking for a $25,000 bond, Your Honor. We're asking for a pretrial release with a GPS monitor and no victim contact.
Judge, he can't make monetary bond, taking light of the fact that he was in a psychological services facility. I mean, it doesn't undermine the culpability, but just take that into consideration. We would have no objection to a GPS level 2 that would ameliorate concern of victim contact. But in light of that, we are asking that he not be given a monetary bond and that you allow him, he can reside with his cousin, and he has family here in South Florida.
And Your Honor, just to reiterate, the state's biggest concern is the safety to the public based on the nature of the allegations, Your Honor.
And that's understandable.
understand your concerns, State.
That's understandable, but Judge, whether there's $25,000 attached or not is not gonna make or break whether he appears at
I
trial.
understand that as well. I will set bond at $10,000 on count 1, and order standard pretrial, no contact with the victim.
Your Honor,
Yes, sir, but keep in mind that you're being recorded, sir. But yes, sir.
Your Honor, I have no funds at all to make bond, but if you guys can put me on the ankle monitor, I promise you, Your Honor, I will respect all authority, Your Honor. I have no funds to make bond at all, Your Honor. Please, Your Honor. I'm supposed to, as soon as I go to my cousin's house, I'm supposed to be going to a drug program called Recovery in Tune. And I could keep in contact with the pretrial probation officer at all times with my drug program that I'm going to attend as soon as I get released, sir.
Okay.
Please, Your Honor. Please, Your Honor.
Sir, based on the serious nature of the allegations, at this juncture, I will decline that request, but the order is reviewable by the trial court, okay?
Just for clarification for the pretrial officer, the defendant is to not possess any guns, weapons, or firearms while he's on pretrial condition on this charge, correct?
Correct. No weapons.
He must remain at least 500 feet away from this alleged victim, correct?
Yes.
Thank you.
Worker at a Baker Act facility or what?
Patient.
Is that correct? It's a worker?
Patient, I believe.
Oh, it's another patient. Understood, Judge.
Corey Moselli.
Mr. Mosley's approaching your main. Good morning, Your Honor.
Good morning, sir. Sir, 2 violations of community control were presented, and each has a no bond hold. I do find probable cause to detain you, sir. And you have a hearing set before your assigned judge on January 17th at 9 a.m.
Judge, is there any chance that I could access my cell phone to call my employers to let them know my situation? I work 2 jobs and I was supposed to be there yesterday and today. That way I could possibly retain employment.
I will sign the order, and counsel's aware of the language. He's going to draft an order now.
I appreciate you.
Don't thank me, thank the attorney who's drafting the order, sir. Michael Rostock.
Judge, I've been informed Mr. Rostock is in regular court. I don't know Judge Rothschild.
All right, we set for the afternoon? Or are we setting for tomorrow to find out what occurred? I'm asking from either party
Tomorrow?
on the two cases. And still have to be addressed. Okay, well, we set them for the afternoon docket. All right. Sean Peterson.
Mr. Peterson is here present, Judge.
Good morning, sir.
Morning.
Let's see. 6 counts have been presented, sir. They include delivering or distributing oxycodone, 2 counts, possession of amphetamine, use of a two-way communication device to commit a felony, child neglect without great bodily harm, and trafficking in oxycodone more than 7 grams but less than 14. And I do find probable cause to detain you, sir. And as to conditions of release.
Yes, Your Honor. We would ask that the bond amounts on counts numbers 1 through 4 and 6 stand, and we're asking in case charge number 5 with the neglect of the child without great bodily harm, that there be a $5,000 bond imposed.
Okay, and from the defense.
Judge, in reference to the bond, in speaking with Mr. Peterson, he's 28 years old, been living here in South Florida his whole entire life. He's self-employed. What he does is detail boats for a living. He gets approximately $300 a week doing that. He lives in Fort Lauderdale. His monthly rent is about it's probably around $900 per month. He right now is he has family that lives in the community, specifically his father, and that's the person that's going to help him post his bond. His father is retired from the Marines. He has, I believe, a pension, what Mr. Peterson advised me. However, at this time, financially, he can't come anywhere close to posting the bond, which is set as to count 6. In reference to count 5 and 6, that's the 2 counts I want to address with the court. Judge, he has priors. I believe he's been clean. He's been without any sort of contact with the criminal justice system for about 4 years now, or over 5 years. Judge, we'd be asking you on count 5 to set a $1,000 bond, and on count 6 to set a $7,500 bond. And Judge, I know I do understand this isn't the time or place, but I believe once Mr. Peterson goes ahead and gives the valid prescription to his attorney, I believe count 6 will be dropped, Judge. But that's provided. I know that's another date in the future to argue all that, Judge, but at this time, we'd be asking for $7,500 on count 6, $1,000 on count 5.
Okay, and sir, I will find probable cause to detain you. I will set bond on count 1 at $2,500, count 2 at $2,500, count 3 at $1,000, count 4 at $1,000, count 5 at $2,000, count 6 at $75,000, and I will order pretrial release, special condition, follow orders of dependency court.
You did not add that special condition on the other person with the child neglect, is that correct?
I definitely, because I ordered that one. Okay, good luck, sir.
Mr. Seaver?
Seaver, Shane Seaver?
Sir?
Sir, one count of possession of cocaine has been presented, and I do find probable cause to detain you. As to conditions of release,
Where's for $1,000 bond, Your Honor? Just the bond that's currently set.
defense?
Judge, in speaking of Mr. Seaver, he's 23 years old, been residing here for 5 years. He works on and off doing construction whenever he can get employment. He has a mailing address. It's his friend specifically that lives in Fort Lauderdale, Mr. Thomas Hipwell. He's right now homeless. However, he did inform me that he believes Mr. Hipwell would allow him to stay with him during the pendency of this case. I know he's spoken to pretrial earlier. I believe he did give the contact information to pretrial regarding Mr. Hipwell. He was hoping that Mr. Hipwell, if he were financially able to, would have already posted his bond. He believes since he's not out, he probably doesn't have the money to post his bond. So he's asking if pretrial can verify his address, if you would release him to pretrial release on this case, Judge.
Judge, I also have an argument as to probable cause.
Okay, I should have heard that part first, but as to the probable cause.
Judge, they stopped him for he was the passenger in a car with the spider web windshield, and that traffic stop, he says that he saw burnt fingers and pinpoint pupils. None of that is in and of itself enough to detain anybody. There's no crime being committed for being a passenger and possibly being under the influence as a passenger. The case Underhill versus State.
Are you arguing motion to suppress, or are you arguing for probable cause?
Well, I'm arguing as well. I guess it would go to motion to suppress, but I want you to take that into consideration with bond.
Okay, I'm aware of the case law in terms of the motion to suppress, but I am aware that we're here for for probable cause determination.
Well, okay, fair enough. Basically, they called the canines to do that and interrupted the mission of the stop in violation of the Fourth Amendment.
And you may have an issue on the motion to suppress, but for bond purposes, I do find probable cause. Mr. Romero, though, you were asking for release to that to the verifiable address.
Correct.
If he hasn't as of yet, and he doesn't, he's going to be held indefinitely until that's verified.
Well, what we'd be asking you is $1,000 pretrial pending verification.
All right, I'll do that, but my hesitation is only that he's going to be held indefinitely. But $1,000 pretrial pending verification.
Correct. If for some reason pretrial can't verify it, then he
Yes.
still has his $1,000 bond.
Your Honor, if we're unable to verify him, then he will have the opportunity to bond out, so it shan't hold him.
Okay. Good luck, sir.
Thank you very much, Rob.
Mr. Mayor, if something happens, please put it on the docket, okay?
Yes, sir.
Justin Campbell.
Mr. Campbell. Come on up, sir.
Mr. Campbell, sir, good morning.
Good morning.
Sir, 2 counts have been presented, a petty theft and a violation of community control. The violation of community control, probation or community control, has a no bond hold, and I do find probable cause to detain you as to both counts. Any arguments on count 1?
No argument for the state, Your Honor.
Defense?
Judge, considering he has a no bond hold on count 2, as far as bond, I have no argument.
All right, I'll set bond at $25 on count 1, no bond on count 2. So you have a hearing before your assigned judge on January 17th at 8:45 a.m., sir. Ismael Pimentel.
Judge, I've been informed Mr. Pimentel bonded.
All right, do find probable cause. He has posted bond. Bond is $1,000.
Judge, Mr. Campbell was right now whispering to my ear, I know you already addressed him, no bond on VOP, petty theft, $25. He's just asking if you could sign a phone order so he can contact his family, let them know he's been arrested.
Who's this, Judge?
I think your colleague is gonna be very upset with you, Mr. Romero, but
Okay.
I will sign an order.
Who is this?
Justin Campbell, the gentleman that we did prior to Mr. Pimentel.
And you can hold on to the orders just in case, until we get through the docket, and
Okay.
then I'll do them all at one time.
Phone order. Oh, okay.
Terrence Walker.
Mr. Walker's present, Judge, he's approaching.
Mr. Walker, sir, you have one count of grand theft auto, one count of possession of MDMA, and I do find probable cause to detain you, sir. As to conditions of release.
Your Honor, we ask for the bond amounts that are currently set stand, and that he will be put on pretrial release with GPS monitor.
Defense?
Mr. Walker's been living here in South Florida his whole life. He's working, he has obligations. Judge, we'd be asking you at this time to leave the standard bond in place. He intends on contacting his he gave me the phone number. I'm gonna be contacting his girlfriend, to let her know to post his monetary bond.
Okay, so you can afford the monetary bond.
I don't know. I'm not sure. I'm not sure about that. I'm not sure if she's gonna be able to post it or not. That's why I asked him to call and see if she's able to post it. I do have a job and I do work.
Does he have priors?
Your Honor.
2017, he has a petty theft conviction. 2012, aggravated battery on a Leo, and resisting without violence conviction. Delivery of MDMA, delivery of cocaine conviction. 2011, looks like a grand theft auto. 2011, delivery of cocaine withheld.
Okay, I will set bond at 1,000 on count 1, 1,000 count 2. No contact with the victim, sir. Good luck. And let's see. Yes.
Judge, I'm sorry, I didn't hear who you called next after Mr. Walker.
I'm going to address Mr. Ali.
Mr. Ali, come on up, please.
This is a failure to appear?
No, I believe it's not in custody.
That's a not in custody capias, okay. And state you filed charges?
All the not in custody information, Your Honor.
Okay. All right. Sir, one count of grand theft has been presented. I do find probable cause to detain you. As to conditions of release. Mr. Romero, do you have anything?
Judge, if the state has nothing to add, at this time, Judge, we'd be asking you to consider releasing Mr. Ali on standard pretrial. He's 54 years old. He's been residing in South Florida for the past 25 years.
Do we have an address? It's on his booking paperwork, it indicates at large.
Judge, he lives in Tamarack with his mother, and his mother right now is elderly. She gets disability, so she's not in a financial position to post his bond. Judge, if then pretrial can verify his address, then we'd be asking you to consider releasing him on pretrial release.
State?
Your Honor, we asked that the bond amount stand. I mean, he's alleged to have stolen a $9,000 watch and never returned it. We asked that no victim contact as well.
Oh, he does have a 2000, is it from December 8th? Yeah, he has an open case, Your Honor, aggravated assault with a deadly weapon.
Correct, he
December.
does have an open case.
All right.
He's currently out on a $10,000 bond. Basically, he was, just released, his mom, his elderly mother that I talked about that collects disability, used all of her savings to post the premium with the bondsman, Judge.
Mr. Romero,
so
did
there-
the allegations in this case occur before or after he was placed on bond?
It would happen before, not,
These allegations,
not after.
these allegations are from January. Oh, actually, no, the warrant was from, let's see. I don't have the offense date. When was the offense date?
In this case, Your Honor, it was July 29, 2017.
All right, and he was placed on bond after that, Mr. Romero?
Yes, Judge.
Okay. In light of that, I'm going to keep the bond at $1,000 and order no contact with the victim.
Yes, Judge.
All right. We still have one case that we have not addressed. But I was informed that Mr. Rubenstein, I saw him come in the courtroom, but I don't know. Mr. Holloway is.
Ms. Holloway is still here, Judge.
Ms. Holloway, I apologize.
He said something about not having the restitution order, or not having the money order, or something like that, so I think just proceed without it.
Okay. Ma'am, did you hire an attorney?
I think my mother or my manager spoke with somebody, but I never spoke with anybody.
Okay, so to your knowledge, you do not have an attorney?
No.
Okay, for the purpose of this hearing, I will appoint the Office of the Public Defender to represent you, ma'am.
Judge, in abundance of caution, you don't want to reset this for this afternoon? If she has an attorney that's already, I don't know if she's retained them, like her, maybe her family, but if
Mr.
a
Vincent,
person
do you
came on
see-
her behalf at least twice
Do you
already?
see, I've seen him walk in and walk out.
He said something about not having the money orders,
So apparently he wasn't paid, so he's not representing her.
Correct, so if we could reset it for this afternoon.
Mr. Romero, I don't think you understand. He's not here because he did not receive compensation.
Oh, I didn't know if he was like right now still talking with the family or anything like that.
He's gone.
Okay, right.
He
This
came
one
in
may
and
have-
spoke briefly and then left.
Okay.
Okay, so, ma'am, 3 counts have been presented. Tampering and a first-degree felony, aggravated stalking, harassment, or cyber stalking, a use of a two-way communication device to facilitate a felony. I do find probable cause to detain you, and arguments as to conditions of release.
Yes, Your Honor, on count 1, it is a punishable by life crime. Your Honor, we're going to be asking that a no bond hold be placed on the defendant. We ask you, that you also find the proof evident presumption great based on the warrant to arrest, the affidavit of arrest. Your Honor, this case arises out of the defendant threatening a victim of an attempted murder. It was the day after the attempted murder trial went forward and after the victim testified. There were threats made on the victim's life by the defendant in this case. Based on that, Your Honor, again, we ask that you find proof evident presumption great and take the defendant into no bond hold. And on count 2, we ask that a $100,000 bond be placed on the defendant with a GPS monitor in the event she does bond out with pretrial release at level 1.
Judges, the probable cause. These don't seem like they're direct threats. They just seem like hyperbole, and they seem like protect the First Amendment. Just take that into consideration when deciding if proof evident and presumption great.
Although the detective is not here, I have been advised that the defendant did admit to making the threats, Your Honor.
Not threats, that's the whole point. I mean, she may have admitted to saying them, but they're not threats. She's not directing them at a certain person. There's captions, hostile captions. And I bet next A, B won't live to take the stand. There's no imminency there.
It says kill him prior to that, Your Honor.
Yes, I do know.
It's not saying I'm gonna kill him. It says maybe
Right.
something.
The court has taken note of the statements, and I will find the state has met its burden. I'll find proof of evident presumption great. I will set bond on count 1 at no bond. I'm sorry, count two, I apologize. Count two at no bond, count one at $10,000, count one at $1,000. Count three is, count three is at 1,000.
Count one is a PBL, Your Honor. Yes.
The tampering and a first degree felony.
Yes, tampering with a witness, first degree felony is the PBL, Your Honor.
That's what I understand now, so no bond. So no bond on that, on count one, 10,000 count two, 1,000 count three. No contact with the victim, no access to devices that have access to the internet, and no access to social media, no contact with the victim. That includes no direct, indirect, telephonic, electronic, third-party contact by any means whatsoever. And I wish you good luck, ma'am.
Judge, before we go on, may you grant me 10 seconds so that my colleague can call me here at the jail? I may want to share additional information with the court.
Court is in a brief recess.
10 seconds, thank you.
Mr. Romero?
Yes, sir.
Yes, sir. Was there anything further?
So Judge, the prosecutor has relayed to me the statute 914.22, and in subsection E, it says it's a life felony punishable by life where the official investigation or official proceeding affected involved the investigation or prosecution of a life or capital felony itself. I'm arguing that this does not. I believe that the underlying crime or trial was for an attempted murder, which is neither a life or capital. And so therefore, this would not be a punishable by life.
Attempted first-degree murder.
Right. That's not a life or that's not life or capital.
Say it.
Your Honor, it's a first-degree felony or a life felony?
Is a first degree automatically a life?
The punishment for attempted first-degree murder is life in prison.
The question is whether or not first-degree murder is a life felony?
Attempted.
Hey, do you have the information in the case that the allegations stem from? To the information, I mean the charging document.
Do you have the PC?
I have the PC. Yeah. No, I have the arrest warrant. I don't have the. Bless you. I don't have the charging document from the case that the alleged victim was a witness in.
This is the brother. That's all we're looking for. We're looking for the defendant name. Okay, thank you. Bye-bye. Your Honor, the defendant's name in that case is,
Oh, I need the do you have the charging document?
yes, the information, Your Honor. And I believe the sentencing is today, Your Honor, just.
The sentencing is today.
Judge, just to preserve the record, I want to cite two Supreme Court cases about whether or not this is a true threat.
And any cases that you cite, I would ask that you provide copies to the court. But you can cite the cases as you wish.
Sure. RAV versus City of St. Paul and Virginia versus Black are the two cases dealing with whether or not something's a true threat. City of St. Paul is 505 U.S., specifically at 388. And it distinguishes true threats and accompanies those threats where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. I don't have the ability to print out these cases, but they're lengthy because they're U.S. Supreme Court cases. But basically, there's an exception to the First Amendment for true threats, and this was like a cross-burning case, and whether or not it intimidated and caused a true threat.
And I believe we already addressed the threat component. That argument was already made. The argument at present is whether or not the count was a PBL. And it is an attempted first-degree murder, and it's actual possession and discharge of a firearm. So yes.
It is a life and, okay.
So the court will stand by its previous ruling.
Yes, Judge.
And no contact with the alleged victim. And I ordered several other conditions as well. No contact, no internet access whatsoever, no social media access, no contact with the victim, third party, direct, indirect, telephonic, electronic, any means at all. Okay. Thank you, Mr. Romero. Does that conclude the morning docket?
Judge, I believe it does. I'm being asked, what time are you gonna start this afternoon?
Depends when I get the paperwork.
I know, we always start on Fridays at 1 o'clock. That's why I'm saying
I did hear that. I said it depends on what time I get the paperwork. So the sooner I get it, the sooner I can start the afternoon docket. Because I do have to review the paperwork before I start the dockets. I'm not concerned with eating lunch, but I am concerned with being able to review with myself, not with you all. I will make sure everyone else can eat lunch, but I need time to review the paperwork. So that concludes the morning docket. Thank you, ladies and gentlemen.